the important process of navigating the H1B process. We have Bob White with Masuda Funai here with us, and then we also have Isra Khan, who is a graduate of our Master of Arts in Industrial Organizational Psychology, to talk a little bit about her experiences as well. With that, I'm going to ask Bob and Isra to each introduce themselves, and feel free to use the chat function to ask questions. We'll ask folks to mute their lines to sort of avoid background noise. Bob will have a formal presentation, and then we'll also hear from Isra after that in reference to her experiences. Thanks again for joining, and I'll go ahead and manage some of the questions in the background. Bob?
Hi, everyone. This is Bob White from Masuda Funai, and as Aisha was saying, I will be giving a presentation. I'll give you a brief background about some F student issues, then we'll talk primarily about the H1B process, and from there we'll just hit briefly on the green card process. So that's the overview.
Great. Isra?
Good afternoon, everybody. My name is Isra Khan, and like Aisha said, I am a graduate of the IO program, the master's degree. I graduated from the Chicago School in 2011, and then from then on, I secured a job where I got my H1B approved, so I'd be happy to talk to you more about that.
Great. Thank you. Bob, and hopefully folks can see this screen. Bob has a PowerPoint put together for us, and I'm going to go ahead and he'll go ahead and run us through some of the important information he's put together.
Okay. And Aisha, you can see the screen, correct?
It looks great.
Oh, okay. Good. So first off, Isra, congratulations on getting an H1B visa, and we'll be talking about the issues for getting H1Bs in a second. But first, I do want to talk about, it's not advancing, hold on, student issues. There we go. And you all have my contact information. If you think of some questions after the presentation, feel free to send me an email because I always respond to emails. So we're going to be talking about the 2014 updates for the immigration laws and policies that affect international students. Because so much is changing on a pretty regular basis, we encourage students to sign up for our complimentary immigration updates. If you do sign up, you'll get one email from us a month with a compilation of all the changes that have occurred in that month. A lot of the issues will affect either your current status or your future status. Some of the issues may not, but again, I think it's a pretty good source, unlike a lot of the unreliable information on the internet and the international communities, because I'm actually writing these updates. So please feel free to sign up. First, we're going to talk about the student issues. But even before that, there's a lot of different governmental agencies involved in immigration, and you really have to know which agency you're either dealing with or going to be dealing with. So I'm just going to give you an overview of all the agencies. First one is U.S. Citizenship and Immigration Services. The acronym is USCIS. Second is Immigration and Customs Enforcement. Now, if you are an F or a J student, you are currently enrolled in the CEPA system, and the CEPA system is run by ICE, Immigration and Customs Enforcement. CBP, anytime you come into the country, you're talking to a CBP officer. DOL, in the future, your employers are going to have to deal with the DOL in the H1B program and also possibly in the green card process. And then lastly, Department of State, anytime that you apply for a visa through one of our consulates abroad, you're talking to a DOS, a DOS official, because they run our consulates abroad. So the biggest issue that we see with students are that you're all very mobile, and anytime that you move, within 10 days of moving, if you're an F or a J student, you have to let the school know. Because the school is required to update that information in the CEVA system. Now, even after you graduate, this obligation continues. up until the time you either depart the U.S. permanently or you change to a different status, maybe the H-1B status. So even though your domestic friends may say goodbye to the Chicago school, you can't. You have to let the school know where you're living, again, up until the time you either depart the U.S. or you change to a different status. Now, if you do change to a different status, you still have to let the government know where you're living. You just don't report that to the school. Instead, you're reporting it to USCIS through the URL that I've given you on the website there. And this obligation actually continues up until the time you become a U.S. citizen. So even if you're a permanent resident, you still have to let the government know where you've moved to within 10 days of moving. So employment options. Many of you may want to work, but you cannot work without employment authorization. And there are some very limited employment programs in the F program. But I'm going to focus on two today. One is called CPT, Curricular Practical Training, which is an internship. The second is called OPT, which is Optional Practical Training. Now, there are a few other limited employment options. Definitely check with the international office to see if you're eligible for one of those options: on-campus employment, severe economic hardship. You can ask the international office about those. But OPT is really the main employment program in the F1 program, so Optional Practical Training. So each student is allowed 12 months of OPT on each higher level of education. So if you came to the U.S. on a baccalaureate level and you graduated and now you're on the master level, you were actually eligible for 2 years of OPT, regular OPT. But it is use it or lose it. It doesn't roll over. So between your baccalaureate program and your master's program, if you didn't use OPT, again, you don't have 2 years now on the master's level. CPT, as I said before, is an internship. And it's your practicum. So you really want to use this because of the whole H1B mess. You really have to try to get in with an employer who could possibly be willing to offer you more long-term employment and go through the H1B process for you. And again, we'll be talking about the H1B process in a second. The good thing is CPT time does not count against OPT time. Unless you work 1 year or more of full-time CPT. You could work 2, 3, 4 years of part-time CPT and not lose your OPT. But if you work 1 year or more of full-time CPT, then you'll lose your OPT time. We always encourage students to save their OPT time until after they graduate because of the whole H1B mess, which we'll be talking about. So if you do save it until before you graduate, you want to apply for OPT 90 days before you graduate. And you go to the international office and they will recommend you for OPT. And then you have to apply for an employment authorization document, EAD card. And you have to figure the government's going to take 90+ days to issue that card. So if you really want to begin working upon graduation, you have to be in the international office 90 days before you graduate to get that recommendation, so then you can apply for that EAD card. There's a second timing factor here. It's called the 30-day rule. So once the international office recommends you for OPT, you actually have to apply for that EAD card within 30 days of receiving that recommendation. If the government receives your application 31 days after getting that recommendation, your application will be denied. It's really a strict deadline. So 90 days before you graduate, get the recommendation from the international office, and then within 30 days of getting that recommendation, make sure your application has been filed with USCIS. Do not procrastinate. Now, your responsibilities during OPT. OPT from an immigration perspective can be either paid or volunteer. It does have to be at least 20 hours a week, and it does have to be related to your major. So if you think you're going to be working at the local Starbucks with your OPT EAD card, think again. It does have to be related to your major. And then you have to notify the school of changes. Changes, as I said before, where you're living. Within 10 days of moving, you have to let the school know. Also, within 10 days of changing employers, you have to let the school know so that they can update the SEVA system. Now, a lot of students think, well, I can't go into the international office 90 days before I graduate because I don't have an employer. Well, you don't need an employer to apply for OPT, but there's a caveat to that. So 6 years ago, the government added an unemployment clock in the OPT program. So for regular OPT, it's a 90-day unemployment clock. So once your OPT EAD card becomes valid and you do not have an employer, you have basically a 90-day clock in which to find that employer. You know, if you're reaching like the 75th day and you don't have an employer, you may want to talk to the international office about possibly some creative options. Again, it doesn't have to be paid employment, it could be volunteering. You may want to start your own business. You could do that too. But whatever you do, just don't exceed the 90-day mark. Now, at the 90th day, if you still don't have an employer, an official from the school is not going to be coming to your house and basically putting handcuffs on you and escorting you to the airport to depart the U.S. That's not their job. But both ICE and USCIS have said that if you do exceed the 90-day window, that it could possibly affect your future benefits. Applying for a change of status in the H1B program, possibly in the green card process. So just the rule of thumb is, you know, whatever you do, try not to exceed the 90-day window. Now, 6 years ago, the government also introduced a second OPT program. It's basically an OPT extension of 17 months called STEM OPT. And this is all based on what your major is and if your employer qualifies as what's called an E-Verify employer. Unfortunately, your majors are not covered under the STEM categories. Hopefully, in the future, the government, ICE, will continue to expand the categories that do qualify for STEM. 3 years ago, they did do an expansion, which at the time I thought covered many of your majors, but unfortunately it depends on how your major is coded, and it's actually a Department of Education coding, and the way that your majors are coded, it's not one of the available options for STEM. So, but again, in the future, hopefully ICE and the government continue to expand the STEM categories because there are a lot of what do qualify, in my opinion, as STEM majors that do not qualify for STEM OPT. So stay tuned on that front. Increased enforcement in the F program. The government has been hiring a lot of new officers, analysts to basically monitor both the schools that are involved in the F program and also the students that are participating in the F program. But if you remain a good person and you continue going to school, you should not have an encounter with an ICE officer. For J students, everything that I've been talking about, OPT, CPT, that's all for F1 students. J students have what's called academic training, and academic training in some regards is better than OPT because regular OPT is only 12 months. Academic training is normally 18 months, And for AT, for academic training, students actually don't have to apply for an employment authorization document. The school can actually authorize them for AT directly. So there are some benefits to AT over OPT. But again, you only have the option based on if you're an F or if you're a J. Now, international travel, pre-graduation versus post-graduation. So anytime that you're going to travel internationally, we always encourage students to check with the international office to confirm that your SEVIS record is okay. If there's a problem with your SEVIS record and you don't know it before traveling internationally, when you re-enter the U.S., you're probably going to be put in secondary inspection, and you could be there for a while and miss your connections, miss whoever's going to pick you up. So we always encourage students, just check your record before you leave. It takes 5 minutes to confirm that your record's okay, and then the school will sign your SEVIS I-20 form confirming that you are still in valid status. So to re-enter the U.S. Pre-graduation, you need a valid passport, the updated I-20 form, and also a valid visa unless you're Canadian or Bahamian. Now, post-graduation, things get a little different. So after you've graduated, once you receive that EAD card, that OPT EAD card, and it becomes valid, then you also need a valid EAD card plus a job offer letter to travel internationally. So, or an employment confirmation letter, job offer letter or employment confirmation letter. So if you're in that 90-day unemployment window, you should not be traveling internationally. If there's a family emergency and you check with the international office, they're going to tell you do not travel internationally. But if it truly is an emergency and you say, I have to go, regardless of how much it costs, come back through O'Hare. Because O'Hare knows the Chicago school. They're going to try to reach out to the Chicago school to find out, your situation, and hopefully you will not be turned around at the port of entry. So if you're living in Chicago, avoid coming back through JFK, Detroit, especially Detroit. Try to come back through Chicago. If you're at the California branch of the school, then you're going to be coming back through LAX, most likely. Now, if the 17-month STEM OPT extension, as we said, as I said previously, unfortunately you're not eligible for that at this time. H1B cap gap relief, we'll be talking in a second about H1B cap gap relief. You just have to remember that, again, to travel internationally, you need the valid EAD card and also the employment confirmation letter or job offer letter. There could be a period, though, during what's called H1B cap gap relief when you do not have a valid EAD card. And again, if you don't have a valid EAD card, you cannot travel internationally post-graduation. I-94 card automation. A lot of students, when we ask, we need a copy of your I-94 record, they tell us, well, the government stopped issuing I-94 cards back in 2013. That is technically correct. But even though they're not issuing physical cards, they are still maintaining a record. And you can actually access your record. I gave you the URL on the website. Every time you come back into the U.S., you really do want to confirm that your record is accurate. If you forget to do it, if you fail to do it, and there's a problem with your record and you try to apply for some sort of benefit, a driver's license, for example, you may encounter an issue. So it's just always best to make sure your record's okay. And if it's not okay, then you can always send us an email and we'll tell you how to get it corrected. From your F status, most of you will go to the H1B status next if you want to continue working in the U.S. The H1B status, it's the primary work vehicle in the U.S. So in this process, you cannot petition for yourself. You do need an employer. So that's before why I was saying CPT, OPT becomes so critical, because you need an employer who's willing to petition for you at a specific time. And we'll be talking about the timing in a second. So what is H1B status? It's for people who are entering into a profession for which they qualify. So your employer is going to be going through either 2 or 3 steps in the H1B process. First part's through the Department of Labor. Second part is through the USCIS. And last part is through the Department of State, through our consulates abroad. So the first step through the Department of Labor, most employers are making 4 attestations to the Department of Labor. If there's going to be any issue, it's normally with the first attestation, which deals with wages. So as part of this process, your employer has to attest that it's going to be offering you the greater of the actual wage or the prevailing wage for your position. The prevailing wage is basically the industry average for your occupation where it's located. And I gave you the URL for the government's prevailing wage system. Now, you don't necessarily, your employer doesn't necessarily have to rely on this system, but what we've been seeing over the past few years is it's become much more accurate, especially if you're going to be working in a major metro area. So it really is a good place to start. If your employer doesn't want to rely on this, it may rely on a private wage survey if the survey qualifies under the Department of Labor's strict criteria. Now, the employer has to offer you the greater of the prevailing or the actual wage. The actual wage is the wage that the employer pays everybody else who's employed in your occupation with your skill set where it's located. So if your employer has 3 other employees in your position and the employer is paying them all $30,000 a year, but the prevailing wage for your position is $35,000 a year, then the employer has to offer you $35,000 a year regardless of what the employer is paying everybody else. So it's just, remember, it's the greater of the 2. Working conditions. So the second attestation that they're making is that the employer is going to be offering you the same benefits that the employer is offering everybody else in your occupation. If the employer offers no benefits, the employer doesn't have to offer you any benefits. The next is work stoppage. So if the employer has a strike, a lockout, or a work stoppage in your occupation where it's located, then the employer cannot go through the H-1B process for you while that job action is going on. Lastly is warnings. So the employer has to place 2 notices of these attestations for 10 business days where your position is located. So a lot of employers hear this requirement and they say, well, I can't go through this process for you because I can't prove that there's no qualified U.S. workers for your position. For most employers, you can very delicately state, I do not believe that there is a labor market test in the H-1B program, because for 95% of the employers, there is no labor market test in the H-1B program. These 2 warnings, they're actually misrepresentation notices. They are not advertisements for your position. The thinking is that if these notices are placed to where you're going to be employed and the employer is not complying with the terms of the attestation, somebody will notify the Department of Labor. So again, it's a misrepresentation notice, not an advertisement for your position. Now, I did say 95%. You know, in immigration, there's a lot of exceptions. Well, this is one of them. So for the 5% or so who employ a lot of H1B non-immigrants, they're called H1B dependent employers, and their employees do not qualify for certain exemptions, then the employer does have to recruit for the position to prove that there's no equally or better qualified U.S. worker. But again, that is the super minority of employers. It is not the majority. It's the super minority of employers that have to go through that extra process, that extra recruitment attestation. Now, the hardest part of this process is the employer has to maintain documentation of all these attestations in what's called a public access file. So the second step of the process is through the USCIS. For the USCIS, the employer is proving two things. Well, actually three things. The first is that your profession qualifies as what's called a specialty occupation. That's the legal term. And psychology does qualify as a specialty occupation, psychologists, etc. So the second part of the test is you must qualify for the position. So if you graduate with your degree and you're going to be a psychologist, then you qualify for an H1B. Your academic background qualifies you for an H. Now the third step is that if the position requires licensure, you have to show that you either have a license or you could do all the duties of the position without licensure, basically sort of an internship. But that will depend upon the state where you're going to be working. So before you apply for an H, you always want to check to make sure what the licensure issues are in the state that you're going to be working in. Now, the third step of the process you may or may not have to do. So this is applying for a visa. Anytime that you re-enter the U.S., you have to have a valid visa, again, unless you're Canadian or Bahamian. When should you apply for a visa? You only need to apply for a visa to re-enter the U.S. If you're an F, you need a valid F1 visa to re-enter the U.S. If you've changed your status to an H1B and you're going to be traveling internationally, you need an H1B visa to re-enter the U.S. Now, I gave you the URL up there for all of the consulates in the world. Before you apply for a visa, you should go to this website and check out the procedures for the consulate where you're going to be applying for the visa, because procedures change all the time, and also the cost changes all the time too. Now, could you be denied an H-1B visa? Some of you may have had an issue applying for or receiving an F1 or J1 visa, because as an F or a J, you're not supposed to want to stay in the U.S. permanently. You cannot have what's called an immigrant intent. However, as an H-1B, you are allowed to have that intent. So you just always have to remember what your intent should be based upon your current status. Okay, but intent may also change over time. But just remember what your current status is and what your current intent should be. Now, can you apply for a visa in Canada or Mexico? Sure, if you're Mexican. Canadians, again, are visa exempt. So, but everybody else is considered to be a third country national. So it's discretionary for everybody else applying for a visa in Canada or Mexico. So could you be denied a visa if you apply in Canada or Mexico? If you've ever had an issue receiving a visa, you've been stuck in a security check, you may not want to apply for a visa in Canada or Mexico. because if you do apply for the visa and you're not issued the visa, you're not going to be allowed to re-enter the U.S. If you're denied the visa, you're going to have to travel from Canada or Mexico directly to your country of last residence. So again, if you've ever had an issue receiving a visa, you may just want to apply in your home country. And who is exempt from the visa requirements? As I said before, Canadians and Bahamians. Okay, so all the issues with the H1B program, there's a couple pages worth here, so let's go through them all. The biggest issue is the H1B quota. So every year our government can only issue so many H1B visas, initial H1B visas. For the past decade, it's been 10 years, the quota's been limited to 65,000. So how is this number counted? Well, it's all based on the government's fiscal year. So the government's fiscal year runs from October 1st through September 30th. October 1st through September 30th. Employers can begin applying for H1B visas 6 months ahead of time. So April 1st, they can begin applying for H1B visas against the following year's H1B quota. So when has the quota been met? So in fiscal year 2007, it was met on April 30th, 2006. So opened up April 1st, 2006. It closed on April 30th, 2006. Fiscal year 2008, 1 day. Fiscal year 2009, 1 day. Fiscal year 2010, January. Fiscal year 2011, December. Fiscal year 2012, November. Fiscal year 2013, June. Fiscal year 2014, 1 day. Fiscal year 2015, 1 day. So what happened in fiscal year 2010, 11, 12, and 13? Well, it was the economy. The economy just was not doing well, so employers were not hiring the way that they were in 2008, 2009, and the way that they've begun to rehire in 2014, and then also this fiscal year, 2015. So what happens when they receive more petitions than the 65,000? Well, in fiscal year 2015, they received a record number. They received a total of 172,500 applications. Back in 2009, they only received 124,000. So we've had a huge increase as the economy has gotten better. So when they receive more than the 65,000, they will basically run a lottery. Everybody's treated the same. No preference for occupation, no preference for country of birth. Everybody's treated the same. If you get lucky, the government keeps your petition and will adjudicate it. If you're not lucky, the government returns the petition with the filing fees and basically rejects the petition. So the future of the quota, we figured that fiscal year 2016, I'm estimating the quota will be probably 200, 225,000. It's only going to increase. So, but the quota itself is not increasing. It's just the number of applications that may be filed is probably going to continue to increase because, again, the economy continues to improve. Now, there are some exemptions to the H-1B quota. So the first one was introduced back in 2009, and it's called a U.S. Master's or Higher Degree Exemption. At the time, it looked great, but it's proven to be really inadequate because there's a cap on this exemption. The cap is 20,000. So back in 2009, they had 33,000 petitions filed against the exemption of 20,000. In fiscal year 2014, 2015, the USCIS didn't even announce the number of people who applied against the U.S. Master's exemption. They just said it was met. So when more people apply than the 20,000, they basically get what I call 2 bites at the apple, because the government will run 2 lotteries. The first one is the U.S. Master's exemption lottery, and then if you're not selected in that lottery, then your application will roll over into the regular quota. So you basically get 2 bites at the apple. So the future of the advanced degree exemption and also the regular H-1B quota. This past year, comprehensive immigration reform passed the Senate. And in the Senate, it would have allowed for an escalator provision for the quota. It would have increased the regular quota to 115,000 from 65,000, and the escalator could go all the way up to 180,000. Also, it would have increased the U.S. Master's exemption, and it would have exempted some individuals with STEM degrees from the quota entirely. But unfortunately, the bill passed the Senate, but it did not move in the House. So the bill is basically going to die at the end of this legislative session, which is at the end of next month. So some other exemptions from the quota. If you're going to be working for a college, university, nonprofit research organization, they are entirely exempt from the quota. And one of those organizations can petition for an H-1B for you at any time because there are no quota considerations. The only thing to keep in mind if you're going to be working for one of those organizations is that if you want to go from one of those organizations into a non-exempt organization, basically the private sector, then you're still subject to the quota. So if you're working for a college and you say, you know, in December, I'm going to leave and I'm going to X company, the college is most likely going to say you can't because of the H-1B quota. So you have to keep that in mind. That's the one potential disadvantage. So is each petition subject to the quota? The answer is no. You just have to get counted one time. So that's the big challenge now. So when should your employer apply for H-1B status for you? April 1st. Most likely the quota will be met during the initial filing period, which is April 1st through April 7th. So you have to be ready to file on April 1st. So changing your status from FJ to H-1B. 6 years ago, the government introduced what's called cap gap relief, which has really been great. So if you graduate and your OPT EAD card is valid from June 1st through May 30th, if your employer applies for you under the H-1B quota, the petition is accepted under the quota and then ultimately approved. Your status is going to be extended. That OPT EAD card is going to be automatically extended until October 1st, which is the earliest date that your H-1B status can become effective. So it's going to allow you to continue living and working in the U.S. During that period. The one exception to that is that card has to expire. The OPT EAD card has to expire between April 1st and September 30th. If the card expires before that, you are not going to be allowed to continue working until October 1st. You may be allowed to continue living in the U.S. There are some exceptions for that. But in order to continue working and living in the U.S., card has to expire between April 1st and September 30th. Now, if your H-1B petition is not approved by September 30th, your cap gap relief automatically expires. The H-1B petition has to be adjudicated prior to October 1st. Otherwise, you may lose your employment authorization after September 30th. So do you have to be concerned about the quota? You know, definitely yes. It's really come back. And you really have to try to set it up so you have multiple chances at the quota, so multiple years to apply for the quota, because the odds of getting in the quota are becoming more difficult as more petitions are being filed. So changing employers, again, you don't have to be concerned about the quota after you've been counted one time. But if you go from company A to company B has to file a petition for you before you can leave company A. It's called H1B portability. If you're thinking to yourself, well, you know, Bob, this just sounds really ridiculous. There has to be other options. Well, there may be other options if you're Canadian, Mexican, Chilean, Singaporean, or Australian. So other non-immigrant options for those nationalities. Canadians and Mexicans have the TN option. There's 67 occupations that are covered under our NAFTA agreement, which may qualify for TN status. H1B1s are for Chileans and Singaporeans. 6,800 H1B1s are set aside for Chileans and Singaporeans. They've never used that number. E3s are for Australians. 10,000 E3s are available to Australian nationals, and they also have never used that entire number. Now, if you're not one of those nationalities, there are possibly other limited options. If you're going to be working for a multinational company, they may send you abroad for a year and bring you back as an L. That's an intra-company transferee. O visas are for people who are extraordinary, and extraordinary in the sense that you can document that you are at the top of your field for the USCIS. And then lastly are E visas, E1, E2 visas. If you're going to be starting your own business or working for a business that is owned primarily by individuals of your nationality, and our government has a treaty with your government, you may qualify for an E visa. So back to H1Bs. So the government is being very aggressive in the H program for about the past 4 years now. So they're aggressively reviewing consulting companies and also small companies. With small companies, they just want to confirm that you're going to be just doing your H1B duties. You're not going to be doing ancillary duties like answering the phone, serving coffee, things like that. So how long can you remain in H1B? The total is 6 years unless you're in the green card process based on employment. So an employer can initially petition for you for up to 3 years, but the max is 6 years. Dependents, if you're an H1B, your dependents will be H4s. Unfortunately, H4s can't work, and they can't obtain Social Security numbers. They can barely drive in certain states, but they can travel internationally. Processing fees. So this is not a cheap program, and anytime the government tinkers with the program, they seem to add a new fee. So the current fees are, the basic fee is $325. The H-1B user fee is $1,500 if your company is more than 26 employees. Less than 26 is $750. There is an H-1B fraud fee of $500. There is an enhanced H-1B fraud fee that has been around for 4 years, but that's only for companies that have more than 50% of their workforce as H-1Bs, and they have more than 50 employees. The enhanced H-1B fraud fee is $2,000. And then the premium processing fee. So this is optional. So if you'd like the government to more timely adjudicate your petition, you can pay the government, your employer can pay the government an extra $1,225 to expedite the processing of the petition. I normally suggest to employers that they save the money because in many circumstances it's just not necessary. But the option is there. Future of fees and procedures. So if the government does pass legislation which increases the quota, they will also most likely be increasing the fees. That Senate bill that passed would have added an extra $2,500 fee to the H-1B program. So, stay tuned. If, again, the program is changed, more numbers are added, there's probably going to be an additional fee. So the green card process, I'm just going to quickly go over. So there's three main ways to get a green card. The first is a visa lottery. So every year the government gives away so many green cards through the visa lottery. It's been 50,000 for many, many years. So if you're from a country that qualifies, you may want to play the visa lottery. Unfortunately, the lottery for the next fiscal year has already closed. It closed on November 2nd. But always check our website in, normally it's early to mid-September, and we'll publish all of the rules and procedures for that year's visa lottery when it becomes available, because you can play yourself. The process is pretty straightforward. Again, if you're from a country that qualifies, and every year the countries that qualify changes. Last year there were 19 countries that did not qualify because they send too many immigrants here each year. But always check the list to see if your country qualifies. If it does, then you should play. And your odds in this program are actually increasing. At its height, they had about 17 million people submitting applications through this lottery. Not this past year, but the year before, they only had about 9 million. So, the odds are increasing. I always say it's better than playing lotto because lotto costs $2. This doesn't cost anything unless you win. The second way to get a green card is based on family relations. Really, the only viable option is marriage to a U.S. citizen, and it's marriage to a U.S. citizen because you want to be married to the U.S. citizen, not because you want the green card. With the Supreme Court striking down DOMA, same-sex marriages are treated exactly the same as opposite-sex marriages. The only thing is, unlike other systems around the world, there does actually have to be a marriage. Partnerships do not count. So you have to be married in a jurisdiction which recognizes the marriage. If you are married to a U.S. citizen and you go through the family-based process, you will be interviewed. And at the interview, they're going to want to confirm that your marriage is genuine. They'll be asking you questions about when you met, where you met, how you met, things like that. And if it appears that you do not know each other, that's when they will separate you and they will start asking more detailed questions. For example, colors of toothbrushes, drawing certain rooms of your house or apartment. And if the officer still isn't satisfied, that's when they will send out an ICE officer to investigate. If you are approved through the family-based process and you've been married for less than 2 years, when you get your green card, it's going to expire after 2 years. And in 2 years, you have to go through another process to prove that it's still for love and not for the green card. The third way to get a green card is based on employment. So if you have an employer, most people in this process do need an employer. There are some exceptions where you can self-petition, but they are very limited. Most people have to go through a labor market test in this process to prove that there are no qualified, willing, or able U.S. workers to fill your position. And your employer is required, most employers are required to test the labor market. And after testing the labor market, if the employer determines that there are no qualified U.S. workers, then the employer submits an application to the Department of Labor, and ultimately the Department of Labor will either agree or they will audit the application to confirm the information that's being provided by the employer. Now, in this process, there's also a limited number of green cards that can be given out each year, and it's all based on supply and demand. Especially for Indian and Chinese nationals, demand exceeds supply. The most extreme example is for Indian nationals in positions which require bachelor's degrees. Right now, they are reviewing applications of individuals who started the process back in November of 2003, so 11 years ago. And the dates don't move day by day. Again, it's just all based on supply and demand. So it could be a very long wait. But the one good thing is if you're pending in the employment-based green card process for at least a year, or you're through the second stage of the process, then the employer may be able to continue extending your H1B status beyond the 6-year maximum period of stay. So it really just turns into a waiting game. Future of the green cards. Again, the Senate bill for comprehensive immigration reform would add more categories, exempt STEM graduates, certain STEM graduates. There was a lot of good stuff dealing with green cards in the CIR bill that passed the Senate, but again, ultimately, that bill is going to die because it's not being moved on by the House. There's also been a lot of talk about executive actions coming out of the White House. So within the next few weeks, the White House may announce certain things that they want to do to change our immigration system. And one may be with green cards and how green cards are counted. So there may be more availability of green cards for people who qualify. So another reason why I would encourage you to sign up for our immigration updates, because, again, a lot may be changing before the end of the year, which may or may not affect you. So that is the end of my part of the presentation.
Thank you. Thanks,
Sure.
Bob. That was very, very thorough and, gosh, always full of lots of information. I know you've got to run, but do we want to give you a moment to anybody to ask any questions before we give Isra a chance to kind of tell us her story with the time that we have left? Bob, if you're able to, maybe hang on the line for as long as you can. I know you've got another call, but
Yeah, no, that's fine.
Okay, I'd like to go ahead and let Isra go ahead and get started. Isra, obviously we've all heard the context of how complex the process is, hence Bob's congratulations to you at the start of our call. Can you tell us a little bit about what your search was like and maybe sort of share some best practices or experiences that you've kind of lived through in the last couple of years since you graduated?
Yeah, sure. So the first thing is, while I was still at the Chicago School, I had experience with CPT and OPT before, but when I had when I did my bachelor's degree at the University of Minnesota. So I kind of had experience with the CPT and OPT process. So I was fairly experienced with that at the Chicago School. So when I was at the Chicago School, I went ahead and did my 2 internships in the IO program that were required, and I did those. I did the last one as CPT, and mainly because I was getting paid. I was a paid intern.
You might have lost you, Isra. All of a sudden you went kind of quiet there.
Job, so then I could get the OPT and then hopefully get sponsored. Unfortunately, at the end of my internship, so CPT internship at the Chicago school, my employer notified me that there was not going to be a position available, so I had to start job searching. My plan was not going according to plan. So just before graduation, I went ahead and started applying for OPT. I did not have a job offer, and as Bob said, you don't require one. You just have that 90-day unemployment clock. So upon graduation, I began job searching like crazy, and that was probably the most difficult time because I did graduate in 2011. The economy was not great. Not many people were hiring at the time. And when I would end up getting interviews, I would talk about needing to get sponsored for an H1B, and 9 times out of 10, the employers would say, unfortunately, we only require applicants that are authorized without sponsorship to work in the U.S. So that's probably going to be the most difficult point in your journey if it's anything like mine. And I think the things to keep in mind is be very aware of your 90-day window. Put contingency plans in place in case you don't get a job offer. Apply everywhere. I started thinking I only want to stay in Chicago, but that plan was not working out, so I started applying all over the country. As soon as I started getting more and more interviews, I changed my strategy a little bit, and during the interviews I would say very confidently and boldly, I won't accept employment unless I am sponsored for an H1B. But on top of that, I would say, this is the process, this is what you need to do. I'm very, very well aware of the process. I know what the filing fees are. I know what the time limits are. So as long as you're very knowledgeable about the process, that will kind of help your employers feel more confident in you. Like, okay, she knows what's involved, so it helped that my employer, my boss, is actually also an immigrant. So that helped the situation as well. But again, the first or second interview, I said, I really am excited about this position. Unfortunately, I will not accept employment unless I get guaranteed that I will get sponsored for a visa, H1. And that was a bold move, but again, if you pair that with knowing exactly what the process is like, then I don't think you'll have a problem. As soon as I got offered the job, I went ahead and used my 12 months of OPT to do my first year of employment, and then a year after that, I went ahead and filed for my H1B. The good thing is that my employer is a very large hospital and cancer center, so they have a lot of research folks that are already on H1B. So our human resources department had an immigration specialist. So they partnered with a local law firm here, immigration law firm, and they handled all of the paperwork. So as when you start filing and preparing for a H1B, be very, very organized. Be very aware of what documents you need and in what order, what size photographs, things like that. They're very, very, very specific. Keep all of your I-20s. I was asked to provide copies of front and backs of all of my I-20s ever since I started school here in the U.S. 10 years ago. So there were a lot of documents that I had to make sure that I could find, even though they weren't useful to me at the time. That's kind of my entire story. If anyone has any questions.
Isra, is there anything? It sounds like you've shared a few tips and best practices. Is there anything when you think back on the process now that you wish you would have known, or that you would suggest others who are getting ready to prepare for this process consider?
Just timing is going to be very important. Be very aware of when you do get your EAD card and when your unemployment clock starts. Just be very aware of what your options are, and I call them danger days, like, when you're coming up against that deadline, you need to know what your plan B or plan C is. Just like my plan A did not work out, I needed to have a plan B or C.
Great. Does anybody have any questions for Isra while she's with us and kind enough to share information about her journey?
I have a question.
Go ahead.
I want to know that once you're about to graduate, it's not necessary that big companies are going to hire you. Like, I'm in the IO program right now. I'm doing my master's, and if I go through my APP database, usually like I come across small companies. Now, they don't have the money to sponsor me. So is it like you said during your interview, you used to say that, oh, I need to be sponsored later on. Is that a bold move? Like, is that a good thing to say?
So to summarize your question, you're asking to tell potential employers that you need an H1B sponsorship. Is that a good move? Is that your question?
That's part of my question. And my second question is that if I don't, like, I know all small companies, and if I don't get a big company who would want to sponsor me, can I just go ahead and work with a small company and look for a bigger company later on? Can I do that?
Sure. So to answer your first question, it really is, it depends on what works the best for you. I was approaching my 90-day deadline, and I began, I never said anything on the first interview. That was my preference. I wanted to make sure that I wanted the job, and I was also doing a little bit of interviewing for prospective employers as well. And then when I had a one-on-one interview with my potential boss, I said very, very candidly, I said, I really am excited about this job, but here's my situation, and I know what the process is. I even offered to pay a portion of the fees if that was an issue. To answer your second question, if you have OPT available, I would absolutely recommend going for any kind of employer you can that's available. So if it's a small company, start out with it and do your OPT that way, but then be very careful about what you want to do later, because if they can't sponsor you after your OPT, then you'll have to figure out your contingency plan. My plan was always to try and find a company that would be able to sponsor me after my OPT, so that was my first choice.
Okay, so you're saying that it's okay to tell the boss that I would be needing sponsorship later on?
I think it's a best practice to give them a heads up, because if you wait until the very last minute and say, by the way, I need sponsorship, that kind of puts them in a difficult position. So I would definitely recommend saying it up front. This is my situation. I know it's very different than, the other people that are citizens, but this is my situation. This is what I need. What can we work together to make something happen?
All right. Thank you.
This is Cindy. I just want to add on top of that, I really second Ms. Sarah's opinion. And when you do your interview, Salme, of course, everyone, like I had my H1 experience a long time ago as well. You don't want to mention about, okay, I need you to sponsor me for H1. You're going to scare your prospective employers.
Yeah.
Because once they know that you're an international student, the majority of the employers will know, if they even come to the stage to interview you. So they already have some kind of experience, or they already know. So I will suggest that you don't mention this like right up front at very, very beginning, but you need to lay the way. You need to show and prove to your employer that you are the best during your work, and work hard on that to convince your employer that you're the person they definitely won't waste their resource on. So, and then they want to hire you for the future position. So want to open it up to you, and so that's the best time when you bring it up that, okay, my time is running out, it's running close, it's time for me to consider my future development. how do you feel about my job? So that's the best time you can bring it up. That's how, like, what I thought and what my experience was as well.
Yeah, it's a good point.
Right.
Can I ask another question for you?
Lisa, do you have time for another question? I don't want to.
Sure. Sure. I have a meeting in 2 minutes, so I will have to leave in 2 minutes. But go ahead, please.
All right. Thanks. I wanted to know what was your process for, how was your process for finding a job? Like, did you use the database, a school database? Did you use, what websites did you use? How did it go?
For my first internship in the IO program, I used the APP database, and I found an internship fairly quickly that way, and I did that for 3 months. For my second internship in the IO program, I found an internship not through the APP database, but through networking. I had a classmate who was doing an internship at a very similar employer. We were very good friends and also colleagues at a different place in the same classes, so she recommended me for an internship. For my actual current job, I used Indeed.com and LinkedIn, and that's how I was able to secure this position currently that I have.
All right. Thank you.
Great.
Of course.
Well, thank you, Isra, so much. I know you've got a meeting to get to. Thank you, everybody, for joining us for a very informative session, and that you have learned a lot. I know Bob was able to share his contact information for folks who need to reach him. Isra, thank you so much for giving us your best practices and walking us through your experience. It was very helpful. Thank you all for joining us. Should you have any questions, you can always contact the International Office or certainly Career Services. And we appreciate your participation in our annual International Education Week event. So thank you. Thanks, Isra.
Thank you very much. Good luck, everybody. Good luck.
Nice talking with you already. Bye.
Bye-bye.